Question 1. In a high-stakes environment where multiple challenges arise in enforcing intellectual property rights, an international technology firm discovers that a competitor has copied its software and is distributing it in multiple countries without authorization. The company holds a U.S. copyright and patent on the software. However, the competitor operates in jurisdictions with weaker IP enforcement mechanisms. What is the most effective legal strategy for the company to pursue? A. File a lawsuit in the United States and seek an international injunction through the World Intellectual Property Organization, WIPO. B. Rely on the Digital Millennium Copyright Act (DIA) to take down the competitor's website. C. Initiate legal action in each country where the infringement occurs, leveraging local copyright and patent laws. D. Demand arbitration through the World Trade Organization (WTO) based on TRIPS filing. Answer. C. Initiate legal action in each country where the infringement occurs, leveraging local copyright and patent laws. Explanation. Intellectual property protection is territorial, meaning copyrights and patents are enforced within the jurisdictions where they are registered, while the Berne Convention ensures automatic copyright recognition among signatories. Enforcement depends on national laws. A is incorrect because WIPO does not enforce rights directly. It provides frameworks, but no global enforcement power. B is incorrect because the DMCA is US-centric and applies to US based service providers. It may help take down infringing content hosted in the US, but not in other countries. D is incorrect. WTO's TRIPS agreement governs international standards for IP, but does not resolve individual disputes. States, not companies, bring TRIPS disputes. The best approach is C, where the firm leverages national IP laws to pursue enforcement in each country where infringement occurs. This emphasizes the territorial nature of IP rights and enforcement mechanisms. Question 2. While investigating a complicated issue between different trademark owners, a fashion company finds that a newly launched brand has a name and logo strikingly similar to its registered trademark. The competing brand operates in an entirely different industry, selling electronic devices, while the fashion company sells luxury apparel. The fashion company sues for trademark infringement, arguing that the similarity dilutes its brand value. Which legal principle is most relevant to determining the outcome of this case? A. The likelihood of confusion standard in trademark infringement cases. B. The trademark dilution doctrine, focusing on famous marks. C. The functionality doctrine, which prevents monopolization of useful product features. D. The fair use defense, which allows limited descriptive use of trademarks. Answer. B. The trademark dilution doctrine, focusing on famous marks. Explanation. Under U.S. trademark law, Lanham Act, standard infringement cases rely on the likelihood of confusion test. However, when a famous mark is used in an unrelated industry, the key issue is dilution, not confusion. It is incorrect because likelihood of confusion applies when consumers might mistakenly associate two brands. Here, since the industries are different, confusion is less likely. B is correct because the Trademark Dilution Revision Act (T) protects famous marks from blurring, weakening uniqueness, or tarnishment, damaging reputation even if consumers are not confused. C is incorrect because the functionality doctrine applies to product design features, e.g., a bottle shape, not logos or names. D is incorrect because fair use allows descriptive, non-trademark uses, e.g., Apple for a fruit seller, not Apple for tech products. This question highlights the difference between confusion-based infringement and dilution claims, a key concept in trademark law. Question 3. When implementing new protocols in a shared environment where confidential business strategies are involved, a pharmaceutical company enters into discussions with a research lab regarding the development of a groundbreaking drug. The company shares proprietary formulations under a signed non-disclosure agreement, and a year later, the research lab files for a patent using the shared information. The pharmaceutical company sues. Trade secret misappropriation. What is the likely legal outcome? A. The research lab owns the patent because it was the first to file under the first-to-file patent system. B. The pharmaceutical company prevails under trade secret law as the information was shared under an NDA. C. The court dismisses the case because trade secrets cannot be enforced once disclosed. D. The research lab and the pharmaceutical company are both co-owners of the patent under joint inventorship laws. Answer. B. The pharmaceutical company prevails under trade secret law as the information was shared under an NDA. Explanation. trade secret protection under the Defend Trade Secrets Act (DTSA) in the U.S. An international framework, c.g. TRIPS agreement, relies on the requirement that information is protected by reasonable measures such as NDAS. If a party wrongfully acquires or uses trade secrets, it constitutes misappropriation, but is incorrect because while the U.S. follows a first-to-file system under the America Invents Act filing, a patent using misappropriated trade secrets can lead to invalidation. B is correct because the NDA legally restricted the use of shared information and filing. A patent without authorization constitutes breach of contract and trade secret misappropriation. C is incorrect because trade secret protection remains enforceable if the owner took measures like NDA. Keep it confidential. D is incorrect because joint inventorship applies only if both parties actively contributed to the invention, not when one wrongfully uses another's proprietary information. This question reinforces trade secret enforcement and patent misappropriation risks, critical for students studying IP or. Question 4. During a comprehensive review of a process that needs improvement, a pharmaceutical company discovers that a competitor has independently developed a drug with an identical molecular composition to one of its patented medications. The company's patent covers the composition of the drug, but the competitor claims to have used an entirely different method to arrive at the same formula. The competitor asserts that since their discovery was independent and not copied from the patent holder, they should not be liable for patent infringement. Under U.S. patent law, which of the following statements is correct? A. The competitor is not liable for patent infringement because they independently developed the invention. B. The competitor is liable for patent infringement because patent protection covers the invention itself, regardless of how it was discovered. C. The competitor is not liable for patent infringement because patent law only protects the process of invention, not the final product. D. The competitor is liable for patent infringement only if the patented drug was explicitly disclosed to them before they developed it. Answer. B. The competitor is liable for patent infringement because patent protection covers the invention itself, regardless of how it was discovered. Explanation. In patent law, particularly under 35 U.S.C. SS 271A, infringement occurs when someone makes, uses, sells, or offers to sell patented invention without authorization. The key principle here is that patent protection applies to the patented invention itself, regardless of whether third party independently discovers the same invention. This means that even if the competitor independently arrived at the same molecular formula, they are still infringing the patent because the patent covers composition itself, not just the method of invention. Option A is incorrect because patent law does not recognize independent invention as defense against infringement. Unlike copyright law, where independent creation is defense, patents grant exclusive rights over the invention itself. Option C is incorrect because patent law protects the final product, the process used to create it, and then in some cases, the use of the product. Option D is incorrect because actual knowledge of patent is not required for infringement to occur. This case highlights the strict liability nature of patent infringement. Intent or independent discovery does not negate infringement if the patented invention is used. Question 5. When implementing new protocols in a shared environment, a software company develops an AI-powered program that generates music tracks based on user inputs. The AI is trained on an extensive dataset containing copyrighted songs. A group of artists sues the company, alleging copyright infringement because their songs were used in training the AI model. The company argues that the AI does not directly copy any song, instead generates original compositions based on patterns it has learned. Under copyright law, which of the following is the most legally sound argument? A. The AI-generated output is protected as fair use because it does not produce identical copies of copyrighted songs. B. The company is liable for copyright infringement if the AI training process involved copying copyrighted works without permission. C. The AI-generated works are free from copyright infringement claims because they were not created by human authors. D. The company is only liable if the AI generates tracks that are substantially similar to existing copyrighted works. Answer. B. The company is liable for copyright infringement if the AI training process involved copying copyrighted works without permission. Explanation. Under U.S. copyright law, particularly under 17 U.S.C. SS 106, the reproduction of copyrighted works without permission, even if used for training AI, is generally considered copyright infringement unless it falls under the fair use doctrine. Courts have been increasingly scrutinizing AI training models, with many legal experts arguing that using copyrighted material without license constitutes infringement. Option A is incorrect because fair use is not automatically granted just because an AI generates new content. Courts consider factors such as the purpose of use, the amount of copyrighted material used and its effect on the market. The wholesale ingestion of copyrighted material to train AI may not qualify as fair use. Option C is incorrect because even though AI-generated works may not have human authorship for copyright purposes, the issue here is the unauthorized use of copyrighted works for training. Option D is incorrect because the liability does not only arise when the output is substantially similar. The act of copying the underlying copyrighted material for AI training itself can be infringing. This case is relevant in the evolving landscape of digital copyright law, particularly as courts grapple with AI-generated works and the scope of fair use in machine learning. Question 6. In a situation where resource allocation becomes contentious, a famous luxury brand discovers that a small fashion startup has begun using a logo similar to its own on handbags and accessories. The luxury brand is internationally known, and while the startup's logo is not identical, it shares the same font, shape, and stylistic elements. The startup argues that their design is different enough to avoid confusion. The luxury brand, however, claims trademark dilution under the Lanham Act and seeks an injunction. Which of the following legal principles is most applicable to this case? A. The luxury brand must prove actual consumer confusion for successful dilution claim. B. The startup is only liable for trademark dilution if it directly competes with the luxury brand in the same market. C. The luxury brand can claim dilution even if there is no likelihood of confusion as long as the startup's logo blurs or tarnishes its distinctive mark. D. The startup's logo is protected under fair use because it does not the luxury brand's trademark exactly. Answer C. The luxury brand can claim dilution even if there is no likelihood of confusion as long as the startup's logo blurs or tarnishes its distinctive mark. Explanation. Under 15 U.S.C. SS 1125 C. Lanham Act, trademark owner can bring dilution claim if another party's use of similar mark either blurs the distinctiveness of the original mark or tarnishes its reputation, even in the absence of consumer confusion. Unlike traditional trademark infringement, dilution protects famous marks from becoming less distinctive over time, regardless of whether the products directly compete. Option A is incorrect because dilution does not require proof of actual consumer confusion. It only requires that the distinctiveness of the famous mark is weakened. Option B is incorrect because trademark dilution applies even if the two companies do not operate in the same industry or market. Option D is incorrect because fair use does not automatically apply when mark is similar in font, shape, and style. The standard for dilution considers whether the famous mark's uniqueness is eroded. This question highlights the difference between traditional trademark infringement based on consumer confusion and trademark dilution based on harm to brand distinctiveness, which is crucial for students studying intellectual property law. Question 7. During a comprehensive review of a process that needs improvement, an automotive company realizes that one of its suppliers has been using a patented manufacturing method to produce engine components. The supplier argues that the method involves a minor, non-essential variation from the patented process and making it non-infringing. The patent owner, however, claims that the doctrine of equivalence applies. Under U.S. patent law, how would a court likely rule in this situation? A. The supplier is not infringing because the change to the patented method is a meaningful and non-trivial modification. B. The supplier is infringing because the doctrine of equivalence applies to minor modifications that perform substantially the same function in substantially the same way to achieve substantially the same result. C. The supplier is not infringing because the patent owner must prove direct copying of the patented method. D. The supplier infringing only if they knew about the patent and intentionally copied it. Answer. B. The supplier is infringing because the doctrine of equivalence applies to minor modifications that perform substantially the same function in substantially the same way to achieve substantially the same result. Explanation. The doctrine of equivalence prevents competitors from making minor, insubstantial changes to a patented invention while still capturing its essence, according to the Graver Tank and Manufacturing Company v. Lind Air Products. 1950 decision. If a variation performs substantially the same function in substantially the same way to achieve substantially the same result, then infringement occurs even if there are slight modifications. Option A is incorrect because a trivial or insubstantial change does not necessarily avoid infringement under this doctrine. Option C is incorrect because direct copying is not required for a finding of patent infringement. Independent development does not absolve liability. Option D is incorrect because intent is not a factor in determining patent infringement. Patent law applies a strict liability standard, meaning infringement can occur even without knowledge of the patent. Thus, the supplier is likely infringing the patent since the modified process achieves the same outcome in a substantially similar way. Question 8. When implementing new protocols in a shared environment, a software company integrates an open source cryptographic algorithm into its commercial security software. The open source license requires any modifications to the algorithm to be released under the same open source terms. However, the company modifies the algorithm and keeps it proprietary. A developer from the open source community discovers this and sues for a violation of license. Which legal principle is at issue and what is the likely outcome? A. The company has violated copyright law because software licenses, including open source agreements, are legally enforceable contracts. B. The company is not liable because open source licenses are voluntary agreements with no legal force. C. The company is only liable if it used the open source software without making any modifications. D. The company is not liable because it did not explicitly agree to the open source license terms. Answer A. The company has violated copyright law because software licenses, including open source agreements, are legally enforceable contracts. Explanation. Open source software licenses are enforceable under copyright law as established in cases such as Jacobson v. Katzer 2008. By using the software, the company implicitly agreed to abide by the terms of the open source license. Violating those terms by keeping proprietary constitutes copyright infringement and breach of contract. Option B is incorrect because open source licenses are legally binding and violations can result in lawsuits. Option C is incorrect because the license applies whether or not modifications were made. Option D is incorrect because acceptance of an open source license is implied by use even if there was no explicit agreement. Thus, the company is liable for violating the open source license and it may be required to release its modifications publicly. Question 9. In a situation where resource allocation becomes contentious, a university research team discovers a breakthrough in battery technology and seeks to patent their invention. However, their research was funded by a government grant under the Bayh-Dole Act. A rival company argues that the university has no right to the patent because the research was publicly funded under U.S. patent law. Who holds the rights to the invention? A. The university automatically owns the patent and the government has no claim to it. B. The federal government automatically owns the patent because public funding was used. C. The university may retain ownership, but the government has marching rights under the Bayh-Dole Act. D. The rival company may use the invention freely because government-funded research cannot be patented. Answer C. The university may retain ownership, but the government has marching rights under the Bayh-Dole Act. Explanation. Under the Bayh-Dole Act, 1980, universities and other institutions receiving federal funding may retain ownership of patents derived from government-funded research. However, the government retains marching rights, meaning it can compel licensing of the patent under certain conditions, such as if the invention is not being commercialized to serve public needs. If national health or safety concerns arise. Option A is incorrect because while the university can retain ownership, it does not have absolute rights due to the government's marching rights. Option B is incorrect because the government does not automatically own patents resulting from federally funded research. Option D is incorrect because government-funded research can be patented provided it follows Bayh-Dole Act provisions. Thus, the university holds the patent but must comply with potential government interventions. Question 10. In a scenario where market dynamics shift unpredictably, a pharmaceutical company launches a new drug to treat a chronic illness. However, within a few months, reports emerge that the drug has severe side effects not disclosed in the initial FDA approval process. The company argues that it followed all testing procedures and was unaware of these effects. What legal principles apply and what are the potential consequences for the company? A. The company is not liable since it complied with FDA regulations. B. The company may be liable under product liability law, specifically under failure to warn and strict liability principles. C. The company can only be held liable if it intentionally concealed adverse effects. D. The company is immune from liability due to preemption by federal law. Answer B. The company may be liable under product liability law, specifically under failure to warn and strict liability principles. Explanation. Under product liability law, a manufacturer is responsible for ensuring that its product is reasonably safe for consumer use. The three main types of product liability claims are design defects. the product is inherently unsafe due to its design, manufacturing defects, the product was made incorrectly or contaminated. Failure to warn. The company did not provide adequate warnings about potential risks. In this case, even if the company followed FDA procedures, it may still be liable under the failure to warn doctrine if it did not properly disclose all risks. Courts have ruled that compliance with federal regulations does not automatically shield companies from liability. CYF v. Levine, 2009. Option A is incorrect because FDA approval does not eliminate liability if new risks emerge. Option C is incorrect because liability applies even if the company was unaware of the risks. Option D is incorrect because federal preemption does not always apply in product liability cases. Thus, the company could face lawsuits and regulatory action under strict liability and failure to warn doctrines. Question 11. When considering the ethical implications of corporate decision-making, a tech company is found to be using personal data without explicit user consent to train AI system. Regulators argue that the company violated privacy laws by collecting data without proper disclosure. What legal consequences might the company face and what ethical considerations are involved? A. The company faces potential penalties, DDR, and other data privacy regulations. B. The company is protected under the fair use doctrine since the data was used for research. C. The company is only liable if the data was sold to third parties. D. The company can avoid liability by issuing a retroactive user agreement update. Answer A. The company faces potential penalties, DDR, and other data privacy regulations. Explanation. Privacy laws such as the General Data Protection Regulation (EDPR) in Europe and the California Consumer Privacy Act (CPA) impose strict requirements on companies that collect and process personal data. These laws typically require explicit user consent before data collection, transparency in how data is used, for users to request data deletion. If the company used personal data without proper disclosure, it could face heavy fines and legal consequences. The ethical issue also revolves around user autonomy and informed consent. People should have control over their personal information. Option B is incorrect because fair use applies primarily to copyrighted material, not personal data. Option C is incorrect because liability applies even if the data was not sold. Option D is incorrect because retroactive policy changes do not negate prior violations. Thus, the company is likely violating privacy laws and ethical standards regarding user consent. Question 12. During the analysis of an evolving technological landscape, a government agency considers whether AI-generated inventions should be eligible for patents. Under current patent laws, an inventor must be a natural person. However, an AI system developed a new pharmaceutical compound without human intervention. Should AI be recognized as an inventor under patent law? A. Yes, because AI systems contribute to innovation just like human inventors. B. No, because patent law requires a human inventor under existing statutes. C. Yes, but only if a human supervised the AI work. D. No, because AI lacks legal rights and cannot hold intellectual property. Answer B. No, because patent law requires a human inventor under existing statutes. Explanation. Under current U.S. patent law, the inventor must be a natural person. In Thaler v. Incu 2021, the U.S. Patent and Trademark Office ruled that AI cannot be listed as an inventor because only human beings can hold intellectual property rights. Option A is incorrect because while AI contributes to innovation, the law currently does not recognize non-human inventors. Option C is incorrect because even if a human supervises AI, the human must have made a significant inventive contribution. Option D is incorrect because while AI lacks legal rights, the main reason for denial is statutory interpretation. Thus, AI-generated inventions cannot currently be patented unless the human is named as the inventor. Question 13. In a case where contractual obligations are tested under extreme circumstances, a company signs a contract to deliver critical medical supplies to a hospital but is later unable to fulfill the order due to an unexpected global supply chain crisis. Can the company be held liable for breach of contract? A. Yes, because contractual obligations remain enforceable regardless of external factors. B. No, if the contract includes a force majeure clause that covers supply chain disruptions. C. Yes, unless the company can prove that no alternatives were available. D. No, because external disruptions automatically void contracts. Answer B. No, if the contract includes a force majeure clause that covers supply chain disruptions. Explanation. A force majeure clause excuses performance under a contract when unforeseen circumstances make fulfillment impossible. Courts typically recognize natural disasters, wars, pandemics, and severe supply chain failures as valid force majeure events. Option A is incorrect because contractual enforcement depends on the specific terms, including force majeure clauses. Option C is incorrect because proving no alternatives exist is not always necessary if the clause applies. Option D is incorrect because contracts are not automatically voided by external events. Force majeure must be explicitly included. Thus, the company's liability depends on the contract's specific terms and whether force majeure applies. Question 14. In a scenario where market dynamics shift unpredictably, a large retail corporation launches a new line of eco-friendly products expecting high demand due to growing consumer interest in sustainability. However, shortly after the launch, a whistleblower reveals that the company misrepresented the environmental benefits of its products. Regulators launch an investigation, and the company faces allegations of greenwashing. What legal and implications arise in this case, and how can the company address the situation? A. The company may face false advertising claims and consumer protection violations. B. The company is not liable if its marketing statements were subjective opinions rather than factual claims. C. The company can avoid legal consequences by issuing a public statement clarifying its position. D. The company can continue its marketing campaign if no customers formally complain. Answer. A. The company may face false advertising claims and consumer protection violations. Explanation. Greenwashing refers to misleading environmental claims used to promote a product. Regulators such as the Federal Trade Commission (FTC) enforce truth in advertising laws, which require companies to provide credible evidence for their claims. Option B is incorrect because objective environmental claims must be substantiated under the FTC Green Guides. Option C is incorrect because a public statement does not erase legal liability if deception occurred. Option D is incorrect because regulatory enforcement does not depend on formal consumer complaints. Investigators can act based on whistleblower reports or independent findings. The company should cooperate with regulators, correct misleading claims, and implement transparency measures. Develop an independent verification process for future sustainability claims. Failing to do so could lead to legal penalties, reputational damage, consumer trust. Question 15. When considering the ethical implications of corporate decision-making, a social media company is accused of prioritizing engagement metrics over user well-being. Internal research suggests that its algorithms contribute to mental health issues, particularly among teenagers. Despite knowing this, the company delays taking action to protect user experience and profitability. What are the ethical and legal responsibilities of the company? Is situation A. The company has a duty of care to mitigate foreseeable harm caused by its platform. B. The company is not responsible for how users engage with its platform. C. The company should only act if government regulators intervene. D. The company can shift liability by requiring users to acknowledge risks. Answer. A. The company has a duty of care to mitigate foreseeable harm caused by its platform. Explanation. Social media companies must balance profit motives with ethical responsibilities. Courts and regulators have started holding tech firms accountable when their platforms contribute to mental health crises. Option B is incorrect because companies can be liable for foreseeable harm caused by their technology. Option C is incorrect because waiting for government intervention is ethically irresponsible. Option D is incorrect because disclaimers do not eliminate liability when a company is aware of harm. To address this issue, the company should modify algorithms to reduce harmful effects, increase transparency in research findings, implement ethical AI guidelines for platform design. Ignoring these risks could lead to lawsuits, regulatory action, and significant reputational damage. Question 16. During the analysis of an evolving technological landscape, an AI-driven financial advising platform is launched to provide automated investment recommendations. However, users report financial losses due to the AI making high-risk investment decisions without properly assessing their risk tolerance. Regulators question whether the company failed in its duty of care to consumers. How should the company address this issue and what risks does it face? A. The company may be liable for negligence if the AI fails to provide reasonable investment advice. B. The company is not liable because users accepted risks when signing up. C. The company can avoid liability by emphasizing that the AI is for educational purposes only. D. The company should only act if lawsuits are filed. Answer A. The company may be liable for negligence if the AI fails to provide reasonable investment advice. Explanation: companies that provide financial advice, whether through humans or AI, must follow fiduciary responsibilities and regulatory guidelines. Courts may hold the company liable if the AI did not assess user risk profiles properly, the company failed to disclose the risks adequately. Option B is incorrect because disclaimers do not eliminate negligence claims. Option C is incorrect because the platform actively influenced investment decisions. Option D is incorrect because companies should act proactively, not reactively, to mitigate legal risks. The company should improve AI transparency and risk disclosures, enhance regulatory compliance with financial laws, implement human oversight for high-risk transactions. Failing to do so could result in SEC investigations, financial losses, and loss of consumer trust. Question 17. In a scenario where regulatory policies are constantly evolving, a pharmaceutical company launches a new prescription drug after receiving expedited FDA approval under the Special Fast Track program. However, post-market studies reveal that the drug causes severe side effects in certain patients, raising concerns about whether the approval process was too rushed. What legal and ethical responsibilities does the company have, and what actions should be taken to mitigate potential consequences? A. The company must immediately report adverse effects to the FDA and take corrective measures. B. The company is not responsible as long as the drug was approved through legal channels. C. The company should wait for more data before acting. D. The company can minimize liability by shifting blame to prescribing doctors. Answer A. The company must immediately report adverse effects to the FDA and take corrective measures. Explanation: pharmaceutical companies are legally required to monitor and report adverse drug reactions under the FDA's post-marketing surveillance regulations. Option B is incorrect because regulatory approval does not eliminate companies' duty to monitor safety. Option C is incorrect because delaying action can result in lawsuits and regulatory penalties. Option D is incorrect because prescribing doctors rely on accurate information from the company. To address this, the company should conduct further safety studies, work with regulators to revise warnings or recall the drug if necessary, implement better risk assessment measures for future drugs. Failing to act could lead to FDA sanctions, lawsuits, and public distrust. Question 18. When considering the impact of technological advancements on consumer rights, an e-commerce giant launches a new AI-powered chatbot to handle customer service inquiries. However, users report that the chatbot misleads them about return policies, causing financial losses and regulatory scrutiny. What legal challenges might the company face, and how can it resolve these issues? A. The company may be held liable for deceptive trade practices under consumer protection laws. B. The company is not responsible if customers did not verify chatbot responses with human agents. C. The company should only take action if government regulators file complaints. D. The company can avoid liability by updating its terms of service. Answer A. The company may be held liable for deceptive trade practices under consumer protection laws. Explanation: companies must ensure that AI systems provide accurate and fair information. The Federal Trade Commission (FTC) and consumer protection laws prohibit deceptive business practices. Option B is incorrect because the company is responsible for chatbot errors. Option C is incorrect because proactive compliance is key. Option D is incorrect because terms of service do not excuse misleading practices. To mitigate risks, the company should improve chatbot training and oversight, clearly disclose chatbot limitations to customers, allow easy access to human agents for disputes. Failure to act could result in regulatory fines, lawsuits, and reputational damage. Question 19. As businesses expand into international markets, a technology firm enters a new country where data privacy laws are stricter than those in its home country. The firm collects and stores user data in ways that may violate local laws. How should the company address compliance challenges while maintaining business operations? A. The company must comply with local data protection laws or face penalties. B. The company is not responsible since it follows regulations in its home country. C. The company should wait for a legal challenge before adjusting its practices. D. The company can bypass local laws by partnering with third-party data processors. Answer A. The company must comply with local data protection laws or face penalties. Explanation. Companies operating internationally must comply with local data privacy laws such as Europe's GDPR or China's PIPL. Option B is incorrect because legal compliance applies where data is collected, not just the company's home country. Option C is incorrect because waiting increases legal risk. Option D is incorrect because using third-party processors does not remove liability. To ensure compliance, the company should review and update data practices to align with local laws, implement clear privacy policies for international users, seek legal consultation on cross-border data transfers. Failing to comply could result in hefty fines, lawsuits, and loss of market access. Question 20. In a rapidly changing regulatory environment, a multinational financial institution expands its operations into a new country where anti-money laundering (AML) laws are stricter than in its home country. After launching services, regulators allege that the company's current risk management procedures are insufficient to detect suspicious transactions. What steps should the company take to comply with the new regulatory landscape while maintaining business efficiency? A. The company must immediately update its ML procedures and implement enhanced due diligence. B. The company is not required to change policies if its home country's regulations are followed. C. The company should wait for regulatory action before modifying its compliance measures. D. The company can mitigate risk by shifting compliance responsibilities to third-party vendors. Answer A. The company must immediately update its ML procedures and implement enhanced due diligence. The explanation: compliance with local anti-money laundering laws is crucial for financial institutions operating in new markets. Option B is incorrect because companies must comply with the laws of the country where they operate, not just their home country's regulations. Option C is incorrect because waiting for regulatory action can result in hefty fines and reputational damage. Option D is incorrect because outsourcing compliance does not eliminate corporate responsibility. To comply, the company should conduct comprehensive risk assessments specific to the new country, implement advanced transaction monitoring systems to detect suspicious activities, train employees on the new country's MO regulations. Failure to comply could lead to severe financial penalties, legal actions, and possible business restrictions. Question 21. As companies navigate the complexities of intellectual property law, a software firm accidentally releases a product feature that closely resembles a patented technology owned by a competitor. The competitor files a lawsuit alleging patent infringement, which could result in significant financial damages and a product recall. What strategies should the software firm use to address this legal challenge while protecting its business interests? A. The company should immediately negotiate a licensing agreement with the patent holder. B. The company should ignore the lawsuit and continue selling the product. C. The company should remove the feature and offer refunds to customers. D. The company should attempt to prove that the patent is invalid in court. Answer A. The company should immediately negotiate a licensing agreement with the patent holder. Explanation: intellectual property disputes can lead to substantial financial and reputational losses if not handled properly. Option B is incorrect because ignoring the lawsuit could result in severe legal penalties. Option C is incorrect because removing the feature alone does not address potential damages or legal liability. Option D is incorrect because proving a patent invalid can be expensive and uncertain. The best approach is to engage in settlement negotiations to obtain a licensing agreement, explore alternative design modifications to avoid infringement, strengthen internal patent review processes to prevent future issues. This approach helps protect business operations while minimizing legal exposure. Question 22. As companies expand their global workforce, a multinational corporation implements a new remote work policy across multiple countries. However, employees in Europe raise concerns that the company's data monitoring practices may violate DDR regulations related to employee privacy. How should the company adjust its policies to remain compliant while maintaining productivity? A. The company must ensure compliance with GDPR's employee monitoring provisions. B. The company is not required to modify policies if it operates outside Europe. C. The company should reduce transparency in its monitoring practices. D. The company can justify surveillance as necessary for security reasons. Answer A. The company must ensure compliance with GDPR's employee monitoring provisions. Explanation: European GDPR laws grant employees significant privacy protections even for remote work monitoring. Option B is incorrect because DDI applies to any company that processes EU citizens' data even if based elsewhere. Option C is incorrect because DDR requires transparency in data collection. Option D is incorrect because security concerns do not override legal compliance. To comply, the company should clearly inform employees about monitoring policies, minimize data collection to only what is necessary for business operations, obtain employee consent where required, and allow opt-out options. Failure to comply with EDR can result in multi-million-dollar fines and legal challenges. Question 23. When businesses leverage artificial intelligence in hiring practices, a corporation introduces an AI-driven recruitment system to screen job applicants. However, internal audits reveal that the AI model disproportionately rejects candidates from certain demographic groups, raising concerns about discrimination and regulatory violations. What steps should the company take to ensure fairness and compliance in its process? A. The company must audit and retrain the AI model to eliminate bias. B. The company should ignore complaints unless a lawsuit is filed. C. The company can continue using the AI model since it improves efficiency. D. The company should shift responsibility to the AI vendor. Answer: A. The company must audit and retrain the AI model to eliminate bias. Explanation: many jurisdictions enforce anti-discrimination laws in hiring, requiring fair AI decision-making. Option B is incorrect because ignoring bias issues can lead to lawsuits and regulatory fines. Option C is incorrect because efficiency does not justify unfair hiring practices. Option D is incorrect because the company remains responsible for compliance. To address the issue, the company should review AI training data for bias, incorporate human oversight in hiring decisions, consult legal experts to ensure compliance with employment laws. This approach minimizes legal risks and enhances workplace diversity. Question 24. During a major transformation where existing methods are being replaced, a healthcare organization introduces a new electronic health records system to improve efficiency. However, doctors and nurses struggle to adapt, and medical errors increase due to confusion with the new interface. What steps should the organization take to ensure a smooth transition while maintaining patient safety? A. Enhance training programs and implement a gradual rollout of the system. B. Immediately revert to the previous system to avoid further risks. C. Ignore the initial challenges as employees will adapt over time. D. Rely solely on vendor support as they design the system. Answer: A. Enhance training programs and implement the gradual rollout of the system. Explanation: a smooth transition requires a combination of employee training, phased implementation, and ongoing support. Option B is incorrect because reverting could cause further confusion and waste investment. Option C is incorrect because ignoring challenges can lead to increased medical errors and legal liability. Option D is incorrect because vendors may not understand the specific operational needs of the healthcare facility. A successful approach includes comprehensive training for staff, including simulations, pilot programs before full implementation, support teams available 24/7 during the transition. Question 25. In an environment where different components must interact seamlessly, a large-scale supply chain network integrates automated tracking systems to improve logistics. However, data mismatches occur, leading to delays in shipments and financial losses. What strategies should the company use to resolve these data inconsistencies and improve overall coordination? A. Conduct regular audits and improve system integration across all supply chain partners. B. Ignore the inconsistencies as they will resolve naturally over time. C. Switch to a completely manual tracking system to avoid digital errors. D. Blame third-party vendors for the data mismatches and demand compensation. Answer: A. Conduct regular audits and improve system integration across all supply chain partners. Explanation: supply chain efficiency depends on accurate data flow across different platforms. Option B is incorrect because ignoring data inconsistencies can cause further disruptions. Option C is incorrect because manual systems reduce efficiency and scalability. Option D is incorrect because blaming vendors does not address the root cause. Best practices include cross-platform compatibility testing to ensure seamless data exchange, automated validation tools to detect mismatches in real time, stronger collaboration between internal teams and third-party logistics providers. Question 26. When developing a solution that must address opposing needs, a software company balances security measures and user convenience in its latest authentication system. Strict security increases login difficulties, while easier access raises security concerns. How can the company strike A balance between these two needs. A. Implement multi-factor authentication (MFA) while offering user-friendly options like biometric login. B. Prioritize security only, even if it leads to user dissatisfaction. C. Reduce security requirements as user experience is the top priority. D. Offer users the choice between high security and easy access. Answer: A. Implement multi-factor authentication (MFA) while offering user-friendly options like biometric login. Explanation: balancing security and usability is critical in authentication systems. Option B is incorrect because excessive security can drive users away. Option C is incorrect because weak security increases risk. Option D is incorrect because giving users full control over security levels can create vulnerabilities. The best approach: MFA with adaptive security that adjusts based on risk level. Biometric authentication e.g. fingerprint or facial recognition. User education on security risks and best practices. Question 27. During a seamless transition where continuity must be maintained, a global bank migrates customer data to a new cloud-based infrastructure. Customers experience login issues and some data appears missing during the migration. What should the bank do to ensure minimal disruption while protecting customer trust? A. Use a phased migration strategy with extensive data validation checks. B. Immediately abandon the migration and revert to old systems. C. Blame third-party providers and inform customers that the issue is external. D. Ask customers to manually verify and resubmit missing data. Answer: A. Use a phased migration strategy with extensive data validation checks. Explanation: data migration must be carefully planned to avoid disruptions. Option B is incorrect because reverting could cause even more data inconsistencies. Option C is incorrect because external blame does not resolve customer concerns. Option D is incorrect because placing responsibility on customers damages trust. Best practices: parallel system testing before full deployment. Customer support teams to assist affected users. Automated reconciliation tools to detect and restore missing data. Question 20. While managing a hybrid approach where timing issues arise, a manufacturing company uses a mix of human labor and automated systems. However, delays occur when human operators must synchronize with machine cycles, causing inefficiencies. How can the company optimize workflow timing to improve productivity? A. Use real-time monitoring and predictive scheduling algorithms to align human and machine tasks. B. Reduce the role of human workers and increase automation. C. Manually adjust operations daily based on observed delays. D. Ignore timing mismatches as they are common in hybrid systems. Answer: A. Use real-time monitoring and predictive scheduling algorithms to align human and machine tasks. Explanation: a hybrid workforce requires smart coordination between human and machine operations. Option B is incorrect because human expertise is still essential. Option C is incorrect because manual adjustments are inefficient. Option D is incorrect because ignoring timing issues leads to long-term inefficiencies. The best approach: automated scheduling tools to optimize task assignments, AI-based sensors to track real-time performance, training programs for workers to adapt to machine cycle patterns. Question 29. In a situation where formal requirements conflict with practical needs, a pharmaceutical company must comply with strict regulatory guidelines while also ensuring fast delivery of life-saving drugs to hospitals. However, delays occur because the compliance review process is too lengthy. What strategy should the company adopt to balance regulatory compliance and operational efficiency? A. Implement a streamlined approval process with pre-validated quality control steps. B. Prioritize speed over compliance to ensure quick deliveries. C. Rely solely on regulatory agencies to suggest faster procedures. D. Ignore compliance issues temporarily as hospitals need urgent supplies. Answer: A. Implement a streamlined approval process with pre-validated quality control steps. Explanation: regulatory compliance is essential, but an optimized approval process can prevent unnecessary delays. Option B is incorrect because non-compliance can result in severe legal penalties. Option C is incorrect because companies must proactively improve their internal processes. Option D is incorrect because skipping compliance checks can lead to safety risks and recalls. Best practices: automated compliance tracking to speed up approval, pre-approved risk assessment frameworks to streamline reviews, collaboration with regulators to ensure efficient but compliant workflows. Question 30. When scaling up operations that experience significant bottlenecks, a tech startup expands rapidly but faces server capacity issues and delays in customer support due to increased demand. What approach should the company take to manage rapid growth without compromising service quality? A. Invest in scalable cloud infrastructure and expand customer support teams in phases. B. Maintain existing resources and hope demand stabilizes over time. C. Temporarily stop accepting new customers until infrastructure is upgraded. D. Outsource all customer support to reduce in-house workload. Answer: A. Invest in scalable cloud infrastructure and expand customer support teams in phases. Explanation: Scalability requires both technical and operational expansion. Option B is incorrect because waiting for stabilization can result in lost customers. Option C is incorrect because halting new customers can damage growth momentum. Option D is incorrect because outsourcing all support can reduce service quality. Best practices: cloud-based infrastructure to handle traffic spikes, AI-powered chatbots to assist human support teams, incremental hiring of support staff to match customer growth.